In the 1989 case, Webster versus Reproductive Health Services, the Supreme Court upheld a variety of state restrictions on abortions. The Missouri law banned hospitals that received government subsidies from performing abortions and barred medical personnel, including physicians and nurses, whose salaries were paid in whole or in part by government funds, from participating in abortion procedures. The Missouri law also required viability tests to be performed on any fetus thought to be past 20 weeks. By upholding these regulations, the Webster decision sent the signal to the states that the court was willing to tolerate greater restrictions on access to abortion services. As a result, access to abortion services became much more difficult in some states than in others. In Planned Parenthood v. Casey in 1992, the Supreme Court upheld a Pennsylvania law that required women seeking abortions in the state to wait 24 hours before undergoing the procedure. The law also required the woman to undergo counseling designed to dissuade her from going through with the abortion. Additionally, the Pennsylvania law required parental consent for minor females seeking abortions. And finally, the law contained a husband notification requirement. The Supreme Court upheld all of these restrictions except the husband notification requirement. The court upheld the 24-hour waiting period, the counseling requirement, and the parental consent requirement. Furthermore, many observers who pay close attention to the abortion issue believe that the Supreme Court was one vote shy of directly overturning Roe v. Wade. This made the 1992 presidential election crucial to this issue. If George H.W. Bush had been re-elected, it was clear he would have appointed justices to the courts who were prepared to reverse Roe v. Wade when vacancies opened. Just as predictably, Bill Clinton would appoint justices who would uphold Roe v. Wade. Clinton won the election, of course, preserving Roe v. Wade as the law of the land, at least for a few years. However, with the two appointments made by George W. Bush in 2005, Chief Justice John Roberts and Associate Justice Samuel Alito, the question has once again been raised whether the court is prepared to reverse Roe v. Wade. With the state of South Dakota considering legislation to prohibit abortions, we may not have long to wait to determine how that question will be answered. It is important to remember that if the court does at some point reverse the Roe decision, it will not mean that the court has outlawed abortions. Rather, it will mean that states have the authority to outlaw abortions. The question whether abortions would be legal or prohibited in any state would be sorted out in the legislative process as a political or a public policy question.